first to tell you that the investigation into the tragic death of Nolan Wells needs more transparency. His family deserves answers. But jumping on social media to race bait without a shred of evidence that law enforcement is covering up a murder is not helping.
If you've been following the Nolan Wells case, you've probably noticed something happening in the last 2 weeks that's easy to miss if you're only watching for a single dramatic reveal. This case has quietly split into 2 completely separate legal tracks, running at the same time, with 2 different sets of rules. One track is criminal, a sealed autopsy, a grand jury nobody's convened yet, an investigation moving at its own pace behind closed doors. The other track is civil, preservation letters, subpoenas to 6 tech companies, a lawsuit that hasn't been filed yet but clearly seems to be coming. And in the middle of all of it, one of the friends caught up in this story has now hired his own attorney and sent his own legal warning, not to defend himself against a criminal accusation, but against what he calls outright fabrication spreading online. Today I want to walk you through exactly how all of this actually works, legally, not with dramatic speculation, but with real analysis from a former state attorney who's broken down, piece by piece, what a lawsuit like this would need to prove, what a subpoena can and can't actually get, and why the "nobody saw anything" problem might be the most important detail in this entire case. This is dense, technical material, but I'm going to walk through every part of it in plain language, the way I'd explain it to a friend rather than read it off a page. Let's get into it. Welcome back to the channel. If you're new here, subscribe and let us know in the comments where you're watching from. Everything you're about to hear draws on legal analysis from Dave Aronberg, former Palm Beach state attorney, who broke this down in detail this week, alongside Law and Crime's Jesse Weber. I'm going to walk you through his actual points, one section at a time, explained in plain language rather than legal jargon. And I want to start with the question that I think actually matters most in this entire case. Not a legal technicality, but a simple, human problem nobody's fully explained yet. Here's the tension that both Aronberg and Jesse Weber kept circling back to throughout their entire conversation, and I think it's actually the most important underlying question in this whole case, more than any single piece of evidence.
It's actually the
Horn
organs
Island
of the
isn't
neck.
some
We're
quiet,
talking
deserted
about
stretch of coastline.
the larynx,
Reports
the
place
pharynx,
hundreds of people out there
our
that
windpipe,
day, spread across dozens of boats,
and everything
for
else
what's
that's
become one of the
connected
Mississippi
therein.
Gulf Coast's
That's the
biggest
conveyance to
informal
get
4th
into
of
the
July
law.
gatherings.
So one of the things,
Music,
what they're
coolers,
looking at here,
people
Nancy,
wading between boats,
to put it very bluntly,
kids on paddleboards,
is they're looking,
a full, crowded,
they're looking
chaotic
for
scene.
any
And somewhere in the middle of all that noise
his
and all those
breathing
people,
could have been
an
compromised.
18-year-old, well-liked, apparently surrounded by friends all day, ends up dead in the water, and not one single person, not one, says they saw how it happened. If Nolan was well-liked, if he was in a large crowd, reportedly hundreds of people on that island that day, and something violent happened to him, it's genuinely difficult to believe that not one single person saw it, recorded it, or has come forward about it since. That absence is strange, whichever direction you read it in. Aronberg's ultimate take on this specific tension, that total absence of any witnessed violence on an island with that many people present, made an intentional, violent scenario harder for him to personally believe than a straightforward accidental drowning happening in one specific spot where, simply, nobody happened to be looking at the exact wrong moment. That's not proof. It's a reasoned judgment based on probability and human behavior. The same kind of reasoning any experienced prosecutor uses constantly when weighing which version of events actually makes sense. Keep that question in the back of your mind because it's going to come back up later once we get into the actual physical evidence. But first, let's get into something more concrete, because there's a piece of this case that's genuinely technical and almost nobody's explained it properly yet. This is where the legal analysis gets genuinely technical, and I think it's some of the most useful information in this entire breakdown, because it explains exactly what these subpoenas to TikTok, Snapchat, WhatsApp, Meta, and Life360 can and can't actually accomplish. Aronberg walked through the real mechanics. Some companies will only release account data if the request comes with a subpoena tied to an actual law enforcement investigation. Others will accept a subpoena connected to a civil case instead. But to issue any subpoena at all, you generally need either an already filed lawsuit or a formal legal claim that litigation is being anticipated. That second option is exactly what a preservation letter represents. a formal notice warning a company or an individual that if relevant material gets destroyed after being notified, there could be real legal consequences down the line if a lawsuit eventually follows. It's worth pausing on just how broad that list of subpoenaed platforms actually is. TikTok and Snapchat would hold whatever Nolan and his friends posted or messaged privately. Meta covers both Facebook and Instagram. WhatsApp covers any encrypted messaging between the group. And Life 360 is the one that tends to surprise people. It's a family location sharing app, meaning investigators, or the family's own lawyers, could potentially reconstruct a minute-by-minute map of where every phone in that friend group physically was, before, during, and after Nolan went missing. His bigger point, though, was about how much less mysterious this whole process actually is from a purely technical standpoint than people assume. His framing was direct. This isn't the 1970s anymore. Metadata stored in the cloud means whether something was deleted and exactly when is very much a determinable fact. It just takes real time to actually extract and verify it properly. Now, that subpoena process didn't come out of nowhere. It's connected to something specific that happened with Nolan's own phone. Let's back up and get into that. This is where Aronberg actually pushed back on both sides of the argument, rather than picking a team. The friend's explanation has been consistent. Nobody had a reason to go into Nolan's phone, nobody touched it, and if nobody touched it, there's no reason anything should have been deleted from it. That's logically sound on its face. You can't accidentally delete something you never opened. But Aronberg also flagged something Ben Crump said directly in an interview with Chris Cuomo, that Nolan's mother called his phone repeatedly and got no answer, which Crump said raises real questions worth answering. Here's Aronberg's actual response to that tension, and I think it's the most balanced take on this specific detail that's been offered publicly. He said it's a fair question to raise, but it's not proof of anything on its own. His explanation, the phone was reportedly sitting on the boat without Nolan, it could easily have been on silent mode, and the people around it, in the middle of an actual boat emergency, water rising, everyone focused on the sinking vessel, may genuinely not have noticed or prioritized a ringing phone. He was also clear about something that gets lost in a lot of the online conversation. We don't actually have confirmed proof that photos or videos were deleted from that device. That specific claim remains unproven in either direction, and it's worth not treating it as settled just because it's been repeated so many times online. Before we go further, if you want the next breakdown the moment new filings drop in this case, that's genuinely what the subscribe button is for on this channel. We're tracking both legal tracks in this story in real time, and a lot of what we cover next won't make it into the mainstream coverage until days later. Hit subscribe now so you don't miss the next update, and drop a comment telling me which track you think will actually produce answers first, criminal or civil. Alright, let's keep going. That leads directly into a question that's been debated constantly in the comments on every video about this case. Why are Nolan's friends doing interviews at all? Let's actually get into that. Aronberg's read on this is genuinely worth sitting with because it cuts against the instinct a lot of people have watching this unfold. His logic goes like this. Doing media interviews about an active, high-profile case, without a lawyer sitting next to you, without prepared talking points, just speaking freely, actually exposes you to real legal risk. Anything you say in that setting could potentially be used against you later, in a civil case, in a criminal case, in front of a jury. So when someone chooses to do that anyway, Aronberg's take is that it's at least some evidence they don't feel like they have something to hide. He pointed specifically to Warren Hudson and Trayston Shepard's interviews as examples. Free-flowing, not guarded, not managed by a lawyer's careful phrasing. To him, that read as more consistent with genuine grief over losing a close friend than with people carefully managing a cover story. Now, I want to be fair to the other side of this too, because it's not an airtight argument either way. Plenty of people who've later turned out to be involved in something have also given confident public interviews. But as a general pattern, Aronberg's point about legal exposure is a real one, and it's worth understanding before you jump to conclusions about why someone is or isn't talking publicly. One of those interviews touches on the single fact that's generated more speculation than almost anything else in this case. Why wasn't Nolan on that boat in the first place? Aronberg's answer here was refreshingly mundane. When you're out with a group split across multiple boats, which, remember, there were at least 2 vessels involved that day, and one boat is leaving while it's actively taking on water, it's completely ordinary for someone to say, "I'll catch the next one." Add in that Nolan was reportedly talking to a young woman on the island at the time, and you've got a completely unremarkable explanation for why one person in a large group didn't get on one specific boat at one specific moment. That doesn't resolve everything about this case. It doesn't explain the full 90 minutes between when he was last seen and when the boat actually left, and it doesn't address what happened after. But it's worth taking seriously as a baseline explanation for that specific question. Sometimes the boring answer really is just the boring answer. Now let's get into where all of this is actually heading, because everything we've covered so far connects directly to a much bigger legal move that's now underway. Aronberg laid out the legal shape of what's coming with real precision. What the family appears to be building toward is a wrongful death claim, and he made a point of explaining exactly why that legal path exists as something separate and distinct from a criminal case, because the two operate under completely different rules. A criminal conviction requires proof beyond a reasonable doubt, the highest standard in our legal system. A civil claim only requires a preponderance of the evidence, which just means more likely than not, true or false, roughly 51% versus 49%. Aronberg used the reference point almost everyone already knows to explain this. O.J. Simpson was found not guilty in his criminal trial under that higher beyond a reasonable doubt standard, but was later found liable in the civil case brought by the victims' families under that lower preponderance standard. Same underlying facts, two different legal outcomes, because the bar for proof was different in each courtroom. His read on the family's overall strategy connects directly back to something they've already done once before. They commissioned their own independent autopsy specifically because they didn't fully trust the pace or transparency of the official state investigation. Building a parallel civil track now, preservation letters, eventual subpoenas, depositions down the road, is really an extension of that exact same instinct. If you don't trust one process alone to get you real answers, you build a second process you actually control yourself. That said, Aronberg was honestly skeptical that this civil track would ultimately produce information the criminal investigation wouldn't eventually reveal on its own anyway. Once the state's investigation concludes and evidence gets presented to a grand jury, the autopsy findings and toxicology results become public regardless of what happens on the civil side. So in his assessment, the real value of the civil process right now might be less about discovering something entirely new and more about making absolutely certain nothing relevant gets destroyed in the meantime, while everyone waits on the slower criminal process to run its course. So if a lawsuit really is coming, the next question is obvious. Who could actually be sued, and on what legal grounds? Aronberg got specific about the actual legal mechanics here, because it's not as simple as just naming everyone who was on that island that day. He was direct that you generally cannot sue law enforcement easily. They're protected by something called sovereign immunity, which shields government agencies and officials from most civil claims arising out of how they conduct an investigation. But private citizens, meaning any of Nolan's friends individually, don't have that same protection at all. A viable civil claim against them would most likely need to be built around negligence, establishing that they had some kind of legal duty of care toward Nolan, and that they failed to meet it in a way that contributed to his death. But Aronberg was careful to add a real caution here. A lawsuit filed without genuine evidentiary backing risks getting thrown out early in the process. If a defendant's attorney files what's called a motion to dismiss, and there's no actual underlying legal claim supported by real facts, a judge can end the case before it ever even reaches the discovery phase, before any depositions happen, before any subpoenaed records get reviewed by anyone outside the court. That raises a question that might be the sharpest, most counterintuitive point in this entire breakdown. Does filing a civil case actually get in the way of the criminal one? This is worth slowing down for, because it's not something most people following this case have considered. If civil depositions start happening at the same time as an active criminal investigation, witnesses can end up giving slightly different accounts of the same events in each separate setting, not necessarily because anyone's lying, but because memory shifts, phrasing shifts, emphasis shifts, every single time someone retells a story. That creates exactly the kind of small inconsistency that a defense attorney can exploit later, blowing up a minor discrepancy into a credibility attack on an otherwise honest witness. Beyond that, Aronberg explained that prosecutors are generally wary of any criminal case that appears to follow closely behind related civil litigation, because it can start to look like law enforcement is effectively being used as leverage to pressure a civil settlement. Prosecutors don't want their own investigation perceived as a tool serving a private lawsuit's interests. And if this case ever does reach a criminal trial, there's a very specific, very damaging cross-examination question waiting for any witness who's also a plaintiff in a related civil suit. You have a financial interest in the outcome of this case, don't you? That's a real credibility problem in front of a jury, even for a witness who's telling the complete truth. Because a jury hearing that question has to weigh whether financial motive could be shaping testimony, whether or not it actually is. There's another legal track running alongside all of this too, and it involves something a lot more serious than a civil dispute over facts. Let's get into the harassment side of this case. Aronberg didn't hedge at all here, and I think his clarity is genuinely useful. Death threats are illegal. Threats of violence are illegal. Extortion is illegal. Full stop, no grey area. And he noted this exact pattern. People connected to a high-profile case facing sustained harassment has shown up before in other cases that got this much public attention, pointing specifically to the Karen Reed case as a comparison, where people connected to the victim's own family faced ongoing harassment for years afterward. His explanation for why this keeps happening over and over across completely unrelated cases, online anonymity, creates a kind of false courage in people. His actual phrasing was that the internet turns a keyboard commando in their mother's basement into someone who would never say the same thing to another person's face. On the legal mechanics of defamation specifically, he made a distinction that's genuinely important to understand. Because the friends involved in this case are private individuals, not public figures, they actually have a meaningfully easier path to winning a defamation claim than a public figure would have. Public figures have to clear a much higher bar called actual malice, proving the person making a false statement either knew it was false or acted with reckless disregard for the truth. Private individuals don't have to clear that same high bar. He was also clear about something that a lot of online commentators seem to misunderstand entirely. Hedging language doesn't provide the legal cover people think it does. Saying allegedly in front of a false accusation doesn't magically make it not defamation. You don't get to sprinkle a word on top of a false statement and have it disappear. And repeating someone else's false claim doesn't insulate you from liability either. If you repeat a defamatory statement, legally, you own it exactly as if you'd said it yourself, originally, from scratch. That single point is worth sitting with for a second, because it's the exact line so much of the online commentary around this case has already crossed. It's easy to think that framing something as a question or wrapping it in "just asking" creates a kind of legal shield. It doesn't. The law looks at what was actually communicated to an audience, not the framing device used to communicate it. Now let's circle back to the physical evidence itself, because this is where Aronberg gave his most direct personal opinion on what actually happened to Nolan. I want to be careful presenting this section because it's genuinely his opinion. An informed one, but an opinion, not a settled fact. He noted that with no signs of blunt force trauma found and no lacerations identified anywhere on the body, the discoloration found at the back of Nolan's head becomes the single central unresolved question in the entire case. His personal read, based on everything publicly available right now, leaned toward an accidental drowning being the most likely explanation, while being explicitly clear that he was speculating ahead of the full toxicology results and the complete state autopsy findings, which remain sealed. He also made a point of specifically defending the credibility of the family's own independent examiner, Dr. Mitchell, and it's worth understanding why. Mitchell didn't hand the family a dramatic, conclusive finding that would confirm foul play. He said the results were inconclusive. Aronberg took that as a real sign of a genuinely careful, honest examination, rather than a result shaped to fit whatever outcome the family might have wanted to hear. If Mitchell had wanted to tell the family what they wanted, inconclusive isn't the answer he would have given them. There's an important pushback worth including here too, one that came directly from Jesse Weber in the actual conversation, citing separate medical examiners he'd spoken with. The red discoloration could genuinely be explained by ordinary decomposition, or it could actually reflect a real blunt force injury, because bruising typically doesn't form the same way after death as it does in living tissue. Both of those explanations remain fully on the table, and neither has been ruled out. Remember that "nobody saw anything" question from the top of this video? This is exactly where it comes back around. I want to bring all of this together now, because I think the real insight from this entire legal breakdown isn't any single point on its own. It's what happens when you look at the criminal and civil tracks side by side, moving at the same time. Think about the incentive structure this actually creates for everyone involved. The friends now have a real reason to be extremely careful about what they say publicly, because anything said in an interview could resurface in a future deposition, under oath, in a civil case that's clearly coming. That's likely part of why some of the more recent public statements, Cole's, Edmonston's family's formal statement, have started to sound more measured and legally reviewed than the earlier, more informal podcast interviews did. As the civil track becomes more real, you'd expect exactly that kind of shift in tone, and it's worth watching for as this continues. At the same time, prosecutors handling the criminal side now have their own reason to move carefully and deliberately, precisely because Aronberg flagged that a criminal case moving too closely behind civil litigation can look like law enforcement is being leveraged for a private lawsuit's benefit. That's likely part of why the timeline on the criminal side has felt so slow and quiet to people watching from the outside. It's not necessarily that nothing's happening. It may be that prosecutors are being deliberately careful not to let the pace or optics of a parallel civil case shape how the criminal investigation unfolds. And underneath both of those tracks sits the same physical evidence, waiting to be fully examined either way. The sealed autopsy, the pending toxicology, whatever the subpoenaed platform data eventually shows. Both legal processes are ultimately racing toward the same underlying set of facts. They're just approaching it through two completely different doors, with two completely different rules for what counts as proof, and two completely different reasons to move at the pace they're each moving at. That's the actual shape of where this case stands right now, once you understand the legal mechanics underneath it, rather than just the headlines. Not a single mystery waiting on one dramatic reveal. Two separate, legitimate systems, each grinding forward at their own necessary pace, both aimed at the same unanswered question a family has been sitting with for weeks now. So here's where all of this legal analysis actually leaves us. Two separate tracks, criminal and civil, moving forward at the same time, on two completely different timelines, under two completely different standards of proof. A sealed autopsy waiting on a grand jury that hasn't been convened yet. A wrongful death claim that appears to be coming, built on a lower legal bar than any criminal case would require. Real, documented harassment that's already crossed into illegal territory, regardless of what actually happened to Nolan. And at the center of it all, a single physical finding, that red discoloration that still has two entirely plausible, entirely different explanations. No cause of death has been confirmed. No charges have been filed against anyone. What's actually happening right now, understood properly, isn't chaos. It's two separate, legitimate legal processes working in parallel at their own necessary pace toward answers that a grieving family and a watching public both still don't have. It's slower than anyone following this case wants, and it's genuinely frustrating to sit with that pace when the underlying question is this serious. But slow and deliberate isn't the same thing as stalled, and understanding the actual legal mechanics behind that pace is a better use of your attention than another round of unverified speculation. We'll keep breaking this down as it develops. Subscribe if you want to understand exactly what's happening in this case, legally, as it happens, not just what's trending.